Thank you, Mr. Chairman, members of the committee. My name is Teresa Tanzi, and the bill before you today, 7575, is an amended bill from the one that was before you last year. It has been amended to reflect the debate that transpired last year, and as a result has made this bill considerably stronger. This bill protects Rhode Island's domestic abuse victims from the threat of armed abusers. It simply codifies existing federal law, and the law is needed because abusers with firearms are killing victims of domestic abuse. The severity of the issue is exemplified by a couple of disturbing statistics. Between 2003 and 2012, there were at least 31 domestic abuse homicides in Rhode Island. Nearly a quarter of these homicides were with guns. The risk of homicide for a woman in a domestic abuse situation increases five-fold when a gun is present. We have evidence clearly indicating that our current laws aren't sufficient to protect women and families from armed abusers. Last year, a groundbreaking study of Rhode Island court documents found that firearms frequently play a role in abuse cases, and you have a copy of that really, truly groundbreaking study in your testimony from Jennifer Boylan from Moms Demand Action. We went through every single court in the state and reviewed every single domestic abuse restraining order request, and the contents of that study is contained in that's in the testimony there. We found that only 5% of domestic abuse protective orders included a requirement that the abuser have his or her gun removed. As a result, at least 325 domestic abusers who appear to have access to guns were not ordered to turn them in. The critical piece of legislation before you makes three crucial changes to Rhode Island law, each designed to keep guns out of the hands of domestic abusers. First, the bill would prohibit gun possession by people convicted of certain domestic abuse crimes. Federal law prohibits people convicted of domestic abuse misdemeanors from possessing guns, but because Rhode Island law does not, it handicaps the ability of our state law enforcement officials to keep domestic abuse victims safe from gun violence. Let me be clear. This amended bill clarifies in every applicable instance that only misdemeanors which involve the use or threat of force of the threatened use of a firearm satisfy the standard for firearm prohibition. In other words, assault and battery convictions would be prohibited. Vandalism convictions would not be prohibited. So your brother argues with your wife on Thanksgiving, but does not use or threaten to use force or a firearm? No prohibition. Only those instances where the perpetrator uses or threatens to use force or a firearm result in surrender in my bill. The majority of states, including our neighbors Connecticut and Massachusetts, as well as Texas, West Virginia, and Colorado, and 21 others around the country, have already taken this important step. Last year, a poll conducted in Rhode Island showed that 83% of Rhode Islanders agree that people convicted of domestic abuse crimes should be prohibited from having guns. Second, the bill would prohibit gun possession by domestic abusers who are subject to protective order, as 25 other states already do. This amended version clarifies that while a person temporarily prohibited may not purchase, carry, transport, or possess a firearm and must surrender firearms he or she already has, he may no longer be the owner of them. According to a study conducted by professors at Johns Hopkins and Michigan State, state laws restricting access to firearms for those under domestic violence restraining orders were associated with a 25% reduction in firearm intimate partner homicide risk. This amended version also clarifies that police shall return firearms to a person who is no longer prohibited upon request if the person produces written documentation indicating that the protective order is no longer has expired or has not been extended and is otherwise not prohibited from possessing a firearm. So we've enacted in this bill, in the new language, a clear pathway for people to get their guns back. This amended version addresses concerns about people convicted using a no contest plea. In Rhode Island, a person charged with certain crimes can plead no contest, and if the court chooses to sentence him or her only to probation, he can be unconvicted if he successfully completes probation. Under H7575, a person who is convicted or pleads nolo to a misdemeanor domestic violence crime is prohibited and must surrender firearms, eliminating the potential conflict in cases where an abuser takes advantage of the nolo plea and eventually becomes unconvicted. We know that there are a few cases, far in between, that a court is less likely to limit punishment to probation if the crime involves violence. And finally, in closing, H7575 would require prohibited domestic abusers to turn in guns they already have to licensed gun dealers or to law enforcement. This piece of the bill is critical. Prohibited abusers cannot pass a background check and buy new guns, but domestic abuse victims aren't provided with enough protection when abusers are able to keep guns they may already have. Again, many states have already taken this crucial step. The clear majority of Rhode Islanders think it is time for Rhode Island to join the list of proactive states that aim to protect women and families from the threat of armed abusers. It should be our top priority to take every step necessary to protect Rhode Island families, and I aim to do everything in my power to curb violence against women. And make no mistakes, H7575 is one of the best ways that we can do both. I thank you for your attention and am happy to take any questions you may have.
Thank you very much, Representative Tanzi. Are there any questions for the sponsor of 7575? Yes, Representative Canario.
Reading through the bill, what happens in the case if the other half lives out of state?
So if they are convicted, they would still be prohibited?
Only within the state of Rhode Island? What would happen if he lived, he or she lived in Connecticut or somewhere other than Rhode Island?
Person?
How would that play out?
I'm not certain about the reciprocity. They are also federally prohibited, so I won't venture to read in between the lines, but I will simply state that. I'm not certain about the reciprocity on the bill. They should be federally, they couldn't pass a federal background check, so they wouldn't be able to purchase a gun in another state, and the federal law prohibits them from doing so as well. So I would venture to say that they would be prohibited no matter the state, but I'm certainly open to correction, not being a lawyer. Thank you.